Well, good morning. I managed to make it this morning. The latest development regarding the sort of sound issue, it seems to definitely be an internet problem. In fact, even just earlier today, I had just literally half an hour ago, I was doing an online lesson and the internet crashed altogether. So I had to just come back in again. So hopefully, fingers crossed, that won't happen again. But I'm just going to check and see what the sound is like at the moment. So I'm just going to check and see what the sound is like at the moment. So I'm just going to okay, that seems to be okay. But I'm just going to keep the video running down there on my phone so I can keep an eye on it. Just make sure that it doesn't crash again. Okay. Well, hi JD, Donna, Sean, and Brendan. Hi there. Let's have a look then at the next part of Richard Leo's testament, and we left off at that point where I said that the Criminal Justice Study Commission was indeed the renamed Avery Task Force. So it's interesting that obviously Richard Leo knew perfectly well about Steve and Brendan back then, at least I would imagine he would do. Well, I think Steve Drisden talks about the fact that, you know, when Steve was arrested, having been an exonerated person, I think that would have piqued his interest. You know, why was a person that's been exonerated, why was he being arrested for something? You know, there's a mischievous thought there, you know, that part of the reason, you know, part of the sort of the payoff, if you like, of rearresting Steve is it makes it look as if it, you know, reflects badly on other people that have been exonerated. You know, maybe they weren't quite as innocent as people would have you believe. I can just imagine them, you know, playing that. Well, we hear that, don't we, from Herman and Gundrum, you know. What if we never let Steve out? Would Teresa still be here? You know. Probably Sheriff Herman, but not in the context that you're talking about. Anyway, okay, question from Steve Drisden. Okay, I want to talk to you about your court testimony and how many times you've testified in court, okay? Yeah. And to the extent referring to the second exhibit, what was that? 316, is that? Yes. Was it what it was? Yes. Would that help you if you need to refer to that? About how many times you've testified? Yes. In court? Yes. Okay. How many times have you been qualified as an expert to testify? Answer: 188 times. Okay. And how many of those times have been in federal court? If you don't mind looking at your report, 10 times. And in the affidavit you filed to this court, you summarized the extent of your court testimony, correct? To that time, yes. And the document that's before you today is included actually updated information, correct? Yes. Okay, so how many times have you testified in state court? Let me say that I have testified. I said I testified 10 times in federal court, but I've also testified 5 other times in military courts. And I think technically military courts are federal courts, so 188 times total. 15 times in federal or military court, so that would mean 173 times in state court. And how many different states have you testified in? Answer: 27. Okay, and have you ever been qualified as an expert in the state of Wisconsin? I have, prior to today, I believe on 2 occasions, one in Appleton, and one time in Chippewa Falls. Anyway. And in Appleton, that would have been the case of State versus Labette. So that's one to have a look at, see what testified in there? Yes. And did you testify as an expert in that case at the suppression hearing? Yes. On issues relating to the whether there was psychological coercion in the underlying interrogation? Yes. And the second time that you testified in Wisconsin was in Chippewa Falls at a trial. It was last month. Okay, do you remember the name of that case? It was Wisconsin versus Timothy Schremener, I think. Okay, valiant effort. And in both of those times that you testified in Wisconsin, was your testimony limited in any way? I don't recall the testimony being limited. Okay, now you testified both at the pre-trial stage and at the trial stage, correct? Yes. And when you testify at the pre-trial stage, what generally do you testify about? When I testify at the pre-trial stage, I usually testify in suppression motions, or what are called motions in limine to exclude basically the same thing. Usually the testimony is both general and specific. The general testimony is about the research on the psychology of police interrogation and psychological coercion and police interrogation practices more generally. Psychological coercion, police interrogation practices more generally. Okay, sound seems to be okay, so let's carry on. And the specific research, of course, is applying that knowledge to the case and opining about whether or not there were any coercive interrogation techniques used. I don't know. Question. I don't know if 3 exhibit can help you, 316, can help you pass through this, but do you know how many times you have testified as an expert in pre-trial stages? Answer, yes. How many? 65 times. Okay, now you also testify in trials, correct? Yes. And when you testify at trials, what is generally the subject matter of your testimony? The subject matter of the testimony is generally the same, except that there's more discussion on the problem of false confessions. Sometimes the topic of false confessions is relevant in pre-trial suppression hearings, sometimes it is not. But it's the primary focus of my testimony at trial. And so when I testify at trial, not only do I testify about what I mentioned earlier in the suppression motions, but also about the social science research on how and why police interrogation can lead to false confessions, what we know about the phenomena of false confessions, the risk factors, both situational, having to do with the interrogation environment, as well as interrogation techniques for false confessions, as well as individual factors that might predispose a suspect to be more vulnerable to suggestion or interrogation influence and make a false confession. Indicia of reliability and unreliability, how social scientists study reliability, the problem of contamination, and sometimes also good and bad police practices. Police manuals will articulate things police should do and shouldn't do. It's largely, I think, based on the research, or the least in part, and so the scope of the testimony usually is much broader in a trial, and it's more focused on the issues related to false confessions, usually. I might offer specific opinions about interrogation practices. Sometimes I'm asked to do that, other times I'm not, about the risks inherent in practices. But I never, however, testify about the ultimate opinion, whether or not I personally think a confession is false. Okay, so you provide a framework for the fact finder to analyze whether or not a confession is reliable or not, but don't reach the ultimate conclusion. Correct. And the framework to understand the psychology of interrogation. Much of this is beyond common knowledge and even counterintuitive. Question: have you ever testified as an expert in post-conviction proceedings? Answer: yes, I have. Do you know how many times? Yes, I do. Exhibit 316 lists 11 times, but since then I've testified in one additional post-conviction proceeding, so 12 times in total. And is the subject matter of your testimony in the post-conviction stage the same? Yes. In my experience, there's often fewer limitations, if any, because of the nature of a post-conviction proceeding. Now, you've testified in a lot of cases, Dr. Leo. Do you testify in every case on which you are asked to consult? Answer, no. Okay, can you give us a sense of how often you testify in relationship to how often you are consulted? Yes. So what I mean by consulted is not just a phone call. I only count consultations when an attorney sends me materials and signs me up, essentially, and gets an authorization so that I'm compensated for my work. So the cases where I am consulted and review documents and provide a professional opinion, about 15 to 20% of those cases I testify in. And this document, 316, lists at least to December 30th the number of cases in which I have consulted. And this goes back almost 15 years. 1132, and then of that, 187 times to December I had testified. So 15 to 20% of the times. The primary reason I don't testify in every case is because defense attorneys often have cases that I can't be helpful in. They're weak cases from my area of expertise. I don't think the interrogations. And then there's Tom Fallon pipes up, I'm going to impose an objection as narrative form because that is unresponsive to his question. Cool. Okay, that's a fair objection. Okay, Steve, I'll ask the question. Sure. Okay. If I understand this right, Dr. Leo, 80 to 85% of the time that you were consulted to be an expert, you don't testify in those cases. Correct. Correct. And in the 15 to 20% when you do, you feel like you have something to add to the case and to the court. Correct? Correct. Question, what is the reason why you don't testify in the other 80 to 85%? What are the reasons? Yes, succinctly stated, my testimony can't be helpful to the attorney who's contacted me. And in some of those cases, they resolve prior to suppression hearing or trial. Okay. And have you ever been consulted with the prosecution about giving expert testimony in one of their cases? Yes. Yeah. Have you ever actually testified for the prosecution? Yes. Can you say how many times you've consulted for the prosecution? I would have to go through my records. I believe no more than half a dozen times. Okay. And how many times have you actually testified for the prosecution? 2 times. What was the substance of your testimony? Can you name the case where you testified? Sure. Well, it was 2 times in one case. The case was the State of California versus Richard Toot. I testified both in a pre-trial suppression motion as well as at a trial. Okay, okay. Sound seems okay. Some of the trying to get my mouth around certain words, not so good. The nature of the testimony was exactly as I described in response to your prior question at the suppression motion and at the trial. Question. So the prosecution asked you to testify about the subject of false confessions and coerced confessions, correct? Question. In that case, okay. Was there another time you testified for the prosecution, or was it just the 2 times in that one case? Correct. Just the 2 times in that one case. Okay. Now then, Steve. Judge, I don't know. At this time, I'd like to tender Dr. Leo as an expert in the field of police interrogations and confessions and the social psychology of police interrogations and confessions. Fox, any objection from the state? And Fallon, create a face. They do so at their peril. Oh no, he says, if there's an objection, I'll make it on a foundation ground as our rules of evidence require. There's not a, all right, necessity for a finding here. That's correct. I'm sorry, I don't understand that objection. So Fox carries on. What he's saying is you do so at your peril. No, sorry, he's saying he will object as apparently questions are raised during the testimony. You're proffering him as an expert witness here. His credentials certainly entitle him under Chapter 907 to be considered an expert witness. Prison. Okay, thank you. Question. Dr. Lear, let's begin with talking about interrogation generally, okay? You spoke about psychological interrogation tactics earlier. What is the leading police interrogation training manual? I think we all know that one. The manual that I referred to earlier, put out by John Reed and Associates. The first author is Fred Inbow. The second author is John Reed. The third author is Joseph Buckley. And the fourth author is Brian Jane. Criminal Interrogations and Confessions in its fourth edition, published in 2001. And Inbow and Reed are no longer alive, correct. Okay, and what's the leading interrogation training firm in the United States? Reed and Associates. Okay, and the president of that firm at the moment, Joseph Buckley. Okay, now aside from the Reed manual, I've taken it you've reviewed other police interrogation training manuals? Yes. Okay. Are there psychological interrogation techniques described in the Reed manual consistent with those that you've seen in other manuals? Yes. And do police typically receive training in psychological interrogation methods and techniques? Yes. More training when they promote to detective or perform the detective function? Yes. They get some training in the academy, and they may get more training as they rise through the ranks. Correct. Okay. Now, in your writings, Richard, you refer to what you call the mind trick of psychological interrogation. Do you know what I'm referring to? Yes. I mean, I think I referred to that once or twice in my writings. What do you mean by the mind trick of psychological interrogation? Well, what I mean is that interrogators have a hard task. They are tasked with getting somebody to confess to committing a crime, which is in the way we conceive of self-interest. So let me start again. Which is in the way we conceive of self-interest in this society against your self-interest, because it will lead to the deprivation of your liberty and many years possibly of incarceration, even possible execution. So the trick, or the mind trick of interrogation, is psychologically manipulating a suspect to perceive that it's in their self-interest to make incriminating statements or confess. Okay, and are there various phases or steps in the psychological interrogation that lead a suspect to confess? Answer, yes. When we say stages and phases, I mean it's a way of psychologically analyzing the process and how things change. But yes, and you can describe some of those changes. Sure. Usually a suspect is isolated. Police are trained to bring them onto their turf and separate them from friends and family. And usually but not always, there's a rapport building phase early on to disarm the suspect and downplay the adversarial aspects of an interrogation. At some point in a custodial interrogation, there will be the Miranda issue will come up, and the police have different ways of giving warnings and maximizing the likelihood of eliciting waivers. But the heart of interrogation, which is really two phases. Now, hold on a sec. Before we get there, can we talk about that rapport building phase? Sure, for a minute, sure. Okay, you mentioned isolating the suspect. Why are police officers trained to isolate a suspect? So they are trained to isolate a suspect because their ultimate goal is to get a confession. And it's believed that you can exert maximal influence on isolated suspect. If you separate a suspect from friends or family or any support network, you break down or weaken the ability of the suspect to deny. And that's what police interrogators are trained to do. And then secondly, isolating a subject is not just about separating them from a support network or familiar environment, but also getting them on the police turf. And so police have carefully orchestrated interrogation rooms that are designed to not allow a suspect to focus on something other than the interrogation, to not distract a suspect. Okay, now you talked about the rapport building phase, and then after the rapport building phase, there's a dramatic shift as the interrogation proceeds, correct? Correct. What happens after this rapport building phase? Answer. Well, after this rapport building phase, usually police launch into one form of another accusatory interrogation. And that's when the full arsenal of techniques, or whichever techniques the interrogators choose to use, are used. And it's the interrogation process proper that I was referring to in my earlier answer when I said the heart of interrogation is really two phases. Question. The start of the interrogation process, the heart of the interrogation as you describe it, how does it generally begin? How do police officers begin the accusation part of the interrogation? Well, usually by confronting a suspect. Well, accusing the suspect of committing the crime, and then challenging their denials and confronting them with real or alleged or made up evidence. Okay, and what are some of the other tactics that you commonly see in the heart of most police interrogations? Well, in the first phase, which we call the first of the two phases, we usually classify this by the goal that the phase seeks to accomplish psychologically, which is convincing a suspect that it's futile to deny. Usually, you see repeated accusations of committing the crime, repeated accusations of lying when denying committing the crime. Usually, you see monologuing by an interrogator. Sometimes you see interpersonal pressure where the interrogator gets closer, sometimes but not always raises their voice, but applies some kind of pressure on the suspect to stop denying and start admitting. Almost always in this phase you see confrontation with evidence, as I alluded to a moment ago, that the interrogator is trying to convince the suspect that the evidence irrefutably establishes the suspect's guilt and therefore it's pointless to deny and no one's going to believe his or her denials. Those techniques are really the heart of the first phase of stage of the interrogation proper. I think that's just of the interrogation proper. I think that's just yep. Let's hold it there because as I say, we do need to break this down into various sections, various parts. Hopefully the sound there was okay for everybody, and we will we'll catch you all again for the next phase. I see Mark's here. I'm not too sure how many other Aussies are here. I suspect a few. And we won't mention the cricket, shall we? Well, go on then, why not? Eunice asked me this morning, have you heard about the cricket? And I just went, and she said, have you spoken to Mark? I said, he's not interested in cricket. He's no interest in cricket whatsoever, particularly as India won the deciding test at the Gabba. After Tim Payne said to the Indians, you wait till we get you to the Gabba at Brisbane. Anyway, hi Sean, Dark Side, Jaznaz. In fact, why don't I just say that? I echo that as well. Hi everyone, and hi Mark. So anyway, let's let's just leave it there, and we'll get back to part 3 probably Thursday. Tomorrow night I've got a planned chat, change of tack, going to go with the accordionist and former Scottish champion Matthew McLennan, and it's looking good for a chat with Woody Mann. I'm still waiting to hear from Mark Godsey, but looking ahead to next Wednesday, I've got only recently retired, the top psychiatrist in the Borders, the top man. In fact, he was the head of the consultants here in the Borders. I'm going to get him to come on and talk about two aspects in particular. One, the P300 murmur that he was studying way long ago. You heard of the P300 murmur? It's what Larry Farwell uses in his brain fingerprinting. So I want to hear a bit more about this P300 murmur, its development, and Cliff's opinion on how it might be used by Dr. Farwell, but also as a top psychiatrist, I want to get his opinions on, what sort of help Steve and Brendan will be requiring once they are exonerated in the not too distant future. So anyway, yes, you're going to have to do me a video, Millbilly, and I'm going to have to try and follow that, because I have no idea. I'll just, as long as the sound stays okay, and I think the issues that I've had have the slight issues, occasional issues, are to do with the internet. As I say, nothing to do with mics, nothing to do with the computer. It's just bad reception, as it were, which can happen anywhere at any time. So anyway, we'll catch you all again soon. And yeah, if you're into accordion music and haven't listened to the words of Matthew, then tune in tomorrow night. As I say, obviously we've got Pete Saturday night. He looks forward to Saturday night. He's well chuffed that the Packers have won every single game since we started chatting. But as I say, I do want to have a chat with Woody Mann, the top guitarist over there in New York. But and then a week tomorrow, hopefully have a chat with Cliff about the P300 murmur and how, what sort of psychiatric help, assistance Steve and Brendan will require. Okay. Well, as you can see, he's kicked me out of his studio, so I'm going to have to try and break in again at some point. Catch you later.